The text mentions full distinct matter for cumulative matter. That which it was filed on Monday. Still did not get restricted. Can this be not a tomorrow?
Tomorrow this bench will not be sitting. Only from Tuesday. I have to go to. I have got to go to Mizoram. I'm going to. So Tuesday will be. Monday is a holiday.
Maybe the logic. It mentions for listing of one unlisted application for today logic. Okay, on 26, I have made mention for today, but matter is not listed today. Okay, in this case, the father of the applicant of 4 has died, and the Satra ceremony will be on next Saturday.
Next Saturday.
13 September.
Right. It is next Saturday.
Yes, sir.
Next Saturday.
Coming Saturday. 13 September.
13 September. 30 or 30. 30. Okay.
I beg to mention,
Huh?
I beg to mention, with the consent of the other side, I beg to mention, I think someone signed. Today we have, the matter has come up for consideration of bail. Kindly possible for day only. We have taken consent from the other side.
Because I want to pray for a judgment made by Ms. on behalf of the state Harris Council, Council for the applicant appellant, which is not objected to by Mr. G. Buyan, additional people. This is the matter after a week.
After vacation.
Why a vacation? Why after vacation? Okay. Just show me the order. Just show me this file. Item 9. The I just show me that. Preparation of paper book is dispensed with. Oh, this is the case where there was a child born to the victim. List the matter in the next week. Next week. Give a date. Next week. On Wednesday or something. Thursday. Next Thursday. All right. No further adjournment will be given in this.
Wait. Well, in this matter,
Item
the wife and for the husband was not responding to messages and many attempts were being made.
Yes.
Eventually, the last occasion, and also was part that further can be made according.
Why can't it be heard today?
He's dealing with the matter.
Okay,
and
we'll take it up after some.
so, the whole day I am being told she's doing date sentence reference there.
We can.
Date sentence reference, she's doing a
Date
date
reference.
sentence. Yes, date
Before
sentence.
before number 1.
Is going to take the
Hold-
code number 7.
Huh?
Code number 7.
Court number 7. Court number 7.
Yes.
This is a division page. Division page. Also today there are 4
No,
division.
special, yes, for that matter. it has
particular
been
matter.
tested.
It's a better way. I am not there. The other side is not there.
So on which date you want?
Tuesday or Wednesday.
But Tuesday,
Because,
Wednesday, I will not be available. So let it be on Friday. Okay. Okay, huh? Or Thursday.
Right.
Fix, huh?
Adjournment prayer has been made on behalf of Ms. S. Jahan on the ground that she is on legs in court number 7. So Ms. B. Boyan, additional PP also submit that the co-accused, that the two co-accused who had prayed for bail submits that the prayer for bail might be made by the two co-accused has been rejected. On the prayer made on behalf of Ms. S. Jahan is the matter on when?
Fifth.
Fifth.
Repeat the law.
Yes.
I prefer adjournment, but
Why?
just have pardon. I actually not be able to fill in number 1.
Yes, you have to give prior information. You cannot just think. You are the counsel?
Yeah, however, I have to engage Kama. He is on only the I filed earlier lordship, so not in the we get engage in the lordship in the forum engage.
But as
I
per
will fill in
the
number 1, brother.
as per the notification issued by this court. For adjournment, you have got to give a prior slip. You have not given.
Okay, actually, very frankly, lordship, I also need.
Why? For us also, we saw it only last night. How does it matter?
Very sorry, Lord.
We can all do it together. I can give you my copy. We can share one copy.
Okay, I understand.
When do you want? When do you want to hear this matter?
I will inform after 5 minutes.
What do you mean?
I'll also consult the Kama lord.
No. When do you want it fixed? Which date?
Because that's why I have to ask him what.
What do you mean you've got to ask him?
So if kindly possible for typing a senior is on like being senior is necessary for the informant. So let the matter be taken out after some time. He can
Who's your senior?
take a minute.
Make him. There are some eyewitnesses also, I think. Lots of 5, 6 eyewitnesses.
I mean, if it can have only affiliate number 1.
Maybe you appear for one or
Counselor.
no, that does not matter. But you see, we'll take it up next week. We cannot adjourn like this. Huh? Because they want one adjustment, okay, we'll give. But no further adjustment. It's wasting our time.
I'm very sorry, Lord.
You are 3, 4, 5, 7, 9, 10, 11. They are all eyewitnesses. That's why I moved on to agenda.
7 eyewitnesses.
Yes. Right.
There's oral declaration.
Adjournment prayer has been made on behalf of Mr. Z. Kamar, learned counsel for the appellant.
Right.
For number
Thank you,
1.
sir.
For the appellant number 1. No prior adjournment request in writing has been made. Which would have been in consonance with the notification issued by this court. In February, when was it? February 2023, by this court. With regard to prior information being given for prayer for adjournment of a case. We have also noticed that the evidence of PW 3, 4, 5, 7, 9, 10, and 11 appear to indicate that they are eyewitnesses and that there is also dying declaration. List this matter on Tuesday. Thank you. for hearing.
So, in this matter also my detailed state,
Yes, so
so is on legs and is possible for banking.
we have adjourned the
No,
matter.
in item 4.
Oh,
again.
item 4.
Lordship, yesterday they have sent an affidavit in question in regard to the
21. I'm sorry. What is it? Connector. Only in with respect to applicant number 4, I am paying for.
121 says that, what,
Late,
death of sale,
Banu Kalpo. This side.
Raunpura.
Issued by Down.
He is the father of who?
He is the father of applicant number 4.
Applicant 4. Who is the applicant for?
Vikram Khatlo, page 2 of my consultant your
Vikram. Okay. Now, when is the Shraddha?
on 30th, it is 7
13.
30. Only for 7 days or 15 days was my considered.
Now, one question. Can bail be granted, conditional bail, without suspending the sentence?
For interim relief, because
I'm not on that, may or may not, I'm asking about the law. About where we cannot do as we like. No, the question is whether can this be given, can a conditional bail be, or interim bail be given without suspension of sentence?
But I have found a provision Assam person leave an emergency relief rules. Assam prisoners in the jail memorial of provisions are there. There, my lord, in the
Page?
Assam prison 671.
You don't have another copy? Yes,
Lordship 2A, emergency release means a temporary release of a prisoner that may be granted on ground of emergencies like death or serious illness of father, mother, father-in-law, mother-in-law, uncle, and so and so. Then thereafter, your lordship, 2C is the leave, my lord. Leave means the concession of temporary release that may be granted to a prisoner. The sanctioning authority is the jail. Subject to the provision of these rules and notwithstanding anything that is, a prisoner may be granted leave or emergency release by the sanctioning authority. Section 4, when prisoner shall not be granted leave. Habitual offenders. All these stipulations are there.
392 to 402.
Then, section 14, my God. Emergency release,
Rule 14 you mean.
rule 14. Sanctioning authority may subject the provisions of rule 15, grant emergency release to a prisoner on the following grounds to facilitate the inmate's presence in his family during a period of grave emergency, like death or serious illness of father, mother, brother, sister, so and so. And 15, prisoners who are eligible for release on leave shall be considered eligible for emergency release. Lordship, he may approach the sanctioning authority, my lord.
Who is the sanctioning authority?
Sanctioning authority has been defined, my lord. 3, subject to the provision so and so, a prisoner may grant leave. of-
Inspector General of Police.
Yes,
By the time he approaches to.
Lordship, today itself he can. His conduct and all would be assessed by the jail authorities, my lord.
They are from Tirang district.
Huh?
They are from Tirang district. I have to inform them, they will come, they will assess.
No, which,
You file an application,
yes.
will
today
will
itself he
direct
can
that an
file.
application be filed through you, let it be filed through the council. Because you see, I don't know if conditional bail can be given without suspending the session. You have got to show me the law. If the law provides, no problem. But if the law does not provide, then how can we make up the law as we go along?
After half an hour, your lordship take up this matter. After half an hour, I will say,
The law.
there are some judgments that they are on medical ground or on pardon.
Honorable,
Bail was
yes,
granted.
I have also found emergency
No, that is
Yes,
all right.
compassionate
then-
bail,
Huh?
compassionate bail, granted,
Not by
Release.
this court, by Supreme Court.
yes.
I will place that out.
Please, sir.
Within half an hour.
Please, sir. Let us not make a mistake.
Right.
All right.
What is that? Okay. I will give the remainder of the order to, I think, Lakshit. We will list it next week.
Well, regarding maintenance, a case is going on in the family court Silchar,
Ah.
right? This case number 17 of 2020.
No, he has spoken to the council for the response.
He's in Bangalore, I heard.
They are coming next week. So we'll list it next week. This is the matter of six. Huh? You don't have to give it to the luck. Tell the luck. Take it, type of the data. This is the matter. On 6, 10, 25. Just give us this. So you don't have to do it. So we are PW9, page 22.
Yes. PW9 is Surat Tansi. I know the accused is my neighbor. The deceased is the mother of the accused. My father was in Bokpara Medical. I went to see my wife. Sorry, my wife was in. It was about 7 months ago. I heard noise in the hospital. I asked the nurses as to what had happened. The nurses told that the accused committed murder of his mother. Police came there, that the accused was not there. So this is also here.
Father of accused. Correct, he's the father of the accused.
No,
No. That is the neighbor.
this is the mother of the PW9. He's a neighbor.
That is the
of the-
neighbor. Then
I had not stated in processes, I had not stated before the police that the nurses had told me that the accused committed murder of his mother.
neighbor, yes.
PW10. Actually, this neighbor, but he was in the hospital because his wife was there. That's the 10 is Vinod Tanti. I know the accused from the time of the incident. The incident took place about 6 months ago. The line chowkidar of Spring Line told me over phone that the accused beat his mother and she died in the hospital. I went to the hospital with police and saw the dead body. The nurses told that the son of the deceased had beaten her as a result and she died. The dead body was brought home after postmortem. In short, it says, the distance from Bokpara Hospital to the PS is about 4 kilometers. I am the secretary of BDP. No one informed me earlier that the accused has beaten his mother. Prior to this incident, I have received no complaint about the accused beating his mother. So this is past behavior. Then Lordship, PW11 is the IO of the case. Lordship is the last name. Nippon Gopal. On 25-22, I was working as attack officer at Tumtuma PS. On that day at about 9:30 AM, the OC of Tumtuma PS received the telephonic information that a man at Badla Hatta reportedly killed his mother. After receiving that information, DD entry number, Lordship, the language that is used, like killed his mother, where is the evidence? I do not know, the evidence they are giving is killed his mother. So,
Okay, we'll see that.
yes. The,
Basically, you're trying to say that even if they maybe so kill his mother, but then the thing is that whether there was any intention to kill, that's a different issue.
no, I'm not even on that, Lordship. It's not, I'm not going to intention. I'll show Lordship 299 IPC and then 300 and also 32 dying declaration, Lordship. What is the evidence? that
Okay.
was- After, because my argument, Lordship, is total denial because there
Okay,
is no
total.
connection between. I mean, first of all, the prosecution. I'll come to that.
Yes.
also. After receiving that information, DTHP number 422 dated 25/22 was made. The OC of Dumduma PS sent me to the place of occurrence for investigation. I proceeded to the Badlabhata Garden Police Hospital along with my staff and opened MCP. I saw the dead body of a woman in the hospital. I conducted inquest on the dead body of the deceased. The exhibit 2 is the inquest report. The exhibit 2 is signature. Thereafter, I sent the dead body for postmortem examination along with the dead body challan, command certificate, and dead body forwarding dead. Exhibit 3, 4, 5 are my. Afterwards, on receipt of an HR from Hiren Manik, the OC of the Dumduma PS registered Dumduma PS case number so and so under section 302 IPC and endorsed the same to me for investigation. The exhibit 6 is the said HR. The exhibit 6.2 is the endorsement given by the then OC of Dumduma PS. I recorded the statement of the informant and one detained Karmakar at the PA. Then I proceeded to the house of accused Lalu Karmakar. After recording the statement of the accused, I arrested him and forwarded to the court. In the meantime, I visited the place of occurrence. I prepared sketch map of PO. Exhibits P6.
Okay, basically denial. Now, okay, then now
Lordship, then will come to that. During investigation, I came to know from the witnesses that the deceased was physically assaulted by accused. Resultantly, the victim received injury over her belly and she was hospitalized at Garden Hospital. This also, so it is, he's speaking against the accused. I'm saying, where is the injury? Where is the physical assault? Because there was no external injury.
there was a confusion.
Confused, yes, in the abdomen, a bruise. And in the pelvic region. So, Lordship,
A person can die from a punch also. Remember there was this case, this cricketer's case, Punjab. One punch,
so the
this is a lady.
vital,
So
the victim reportedly told about the incident to the nurses, namely Mamuni Soike Hajarika, Srimati Dipali Mahali, and Srimati Radhika Tan. I recorded the statements of those nurses. I forwarded these 3 witnesses to the court for recording their statement under section 1 of the Act. I collected the copy of those statements. I also collected the PM report. After collecting the PM report, I consulted about the case with the OC. The OC has supervised the investigation and advised me to submit the statement. Accordingly, I submitted charge sheet against the exhibit so and so signature. Plus, in cross, it says, in the GD entry number 422 dated 25/22, there is no mention of the name of the accused, name of the deceased, the PO, and the time of incident. During investigation, I came to know that the victim had herself gone to the hospital in the ambulance of Garden Hospital on 19/5/22. But I could not know the time of the victim going to the hospital. I also came to know during investigation that the victim died at about 2 a.m. on 25/22. Prior to the death of the victim, no information, these are important, Lordship, no information was received in the PS regarding she being allegedly assaulted by the accused. During my investigation, I did not go to Longswell Hospital, and so I do not record the statement of any person of Longswell Hospital. I visited the place of occurrence at about 12:30 p.m. on 25/22. Then the rest part is also important. Though I indicated the house of Shivananda Mahali and the shop of Suraj Mahali in the sketch map, I did not record their statement. During investigation, I could not find exactly at which place the accused allegedly assaulted the victim. It is not a fact that I have submitted charge sheet against the accused without making proper investigation into the case. This is the evidence of prosecution, Lordship. And then, Lordship, the 13th statement, Lordship, the learned trial court had one of the circumstances against the accused that the trial court held was that the accused had not taken his mother to the hospital. But Lordship, in his 313 statement, that explanation is coming. Lordship, question number 1, in reply to the
That,
question.
that is to the second hospital, I think. The last
No,
hospital.
he took to the second hospital. First hospital, he explains here, Lordship. The question number 1, he put that he was not taken to the A. That he says, I know this. I did not accompany my mother to the hospital as I went out for work. After he left for work, his mother had gone to the hospital. Then, Lordship, question number 4 also, otherwise he is denying I did not assault my mother. He's saying in all the answers. Only those which he has given an explanation, I'm reading. Question 4, Lordship, next page 30. Yes, my mother expired at Longswell Hospital. I had taken her to Longswell Hospital. He had taken her to the other hospital when she was serious. Then, Lordship, 6 also, he said, yes, my mother died at Longswell Hospital. 7, he said, yes, she went to the hospital in an ambulance. Then 11, Lordship, he says, yes, she expired in the hospital. Because Lordship, what I'm trying to show is that he's not lying about anything. Whatever is true, he's accepting that. And otherwise, he's saying that I did not assault my mother. 12 also, yes, I lived with my mother prior to her death. Then I did not assault I did not assault. These are the answers. Lordship. Then Lordship, let me take Lordship to the 164 statement because the conviction is based on this alleged dying declaration only. 164 statement at page 84, Lordship, first 164 statement. 2 statements are there. This is of Mamuni Soikia Hajri.
Page
84, Lordship.
Yes.
My name is Mamuni Soikia Hajurika and I am a permanent resident of Chipon, Chipsagar. I am presently staying at Bokhara Tea Estate, Dumduma, working as a GNM nurse at Bokhara Tea Estate Hospital. On 19/5/22 at around 9 a.m., here the time is coming 9 a.m. The mother came to the hospital. 9 a.m. in the morning hours when I was doing my duty, a patient named Srimati Reena Nuna, resident of Spring Line, was brought to our hospital in the ambulance. Srimati Reena Nuna informed us that she was physically assaulted by her son in the early morning hours on that same day. After primary examination, I gave Reena Nuna basic first aid. Basic first aid, Lordship will mark this. Basic first aid was given. And also admitted her in the hospital. At around 9 p.m. in the night, Reena Nuna complained of pain in her stomach. So Lordship will see that in the morning when 9 a.m. she is brought in, there is no pain, nothing, there is no external injury, and she was given basic first aid at that point of time. It is only at night that she complained of pain in her stomach. I saw that Reena Nuna's stomach was swell more than normal and she had trouble in peeing. I tried to help Reena Nuna to release her urine using medical prescribed methods, but could not succeed. Later, as her condition grew critical, she was referred to Longswell Central Hospital near Hapsan at around 10 p.m. Later that night, at around 2:15 a.m., I came to know from our ambulance driver that Reena Nuna passed away at around 2 a.m. Reena Nuna's dead body was brought back to our hospital at around 4 a.m. in an ambulance, and the dead body was kept in a separate room. Our pharmacist, Sri Vijay Pine, entered the detail of the dead body patient and informed the Dumduma PA. The police came around 10:30 AM and took the dead body of Reena Nona to conduct the postmortem. Sorry. This is all I have to say. Lordship, she was brought in at 9 AM in the morning. What treatment was she given? If there was an assault, what treatment was given? Prosecution has not brought anything on. Even though this 164 statement was taken on 23rd day of May 2022. No document. What treatment was given? Because Lordship, if there was an assault and she died because of any kind of assault. About assault, I'll be tackling that. But the medical part of it, there is nothing. Because in every case, when there is an assault, what that he was taken.
No, you see, at that particular time, you see, in the morning, she did not say. She said it only in the evening, I think.
No,
Correct. When
they
did
said
she
in the
say?
morning, the evidence they are saying that she came and she said that. But here, they're not saying in
So
the.
just because there is no mention with regard to what treatment was given, what does that imply according to you? That she was not assaulted?
It is not a question of she was assaulted or not. That will come later on, Lucky. But first, if she was given treatment, for what she was given treatment?
You mean the cause of death
Yes,
or what?
cause of injury, cause of death.
Cause of
What-
injury, they have said that it was the son.
But-
Now, is there, that those three nurses, there are three of them, by the way. All of them in their 164 statement have given their statement that
two
the
have given one.
three. You please look at page page 81 also. Page 81 is PW3. 81 is PW3. 84 is PW4 and
Yes, I've marked.
yes. So all three of them have given similar statement.
Hmm.
Now they are all independent witnesses, no enmity, they've got no idea. They are not related, they are nurses. Now why should they tell a lie?
Lordship, why should they tell a lie? Because if the death was because of their own negligence. Lordship, she was there in the hospital from 9 in the morning, according to them. She said that the pain started, according to them, their own 164 statement, 9 PM, the pain started, and then she was sent. So if her death was due to their negligence, their treatment negligence, Lordship. So naturally they'll try to, all these three.
They are nurses, madam. They
Yes.
cannot diagnose.
No, they give treatment. They said they gave first aid. They were the. No doctor has given her any treatment. Only the nurses were giving treatment.
So whose fault is it?
Lordship,
So whose fault is it?
that she was not
Not
treated
treated.
by a
Is
doctor.
it? Yes. Is it the fault of the nurse?
No, Lordship, question is if the treatment, if they are not qualified. Lordship is saying-
See, nurses don't give treatment. They only follow the treatment given by the advice by the prescription given by the doctor.
Yes.
Otherwise, of course, the normal, they will give the normal head, the paracetamol and whatnot,
Oh.
and maybe drip. But they cannot diagnose as such. They don't have the expertise to do that.
Correct.
Then
Then
how are
what
you?
were they doing, Lordship? Then what were they doing?
They were on duty looking after whatever. You see, have you gone to this PHCs in different villages? Have you gone?
I have just seen them.
Yes,
my-
you go to these. You go to these villages. You go to these. It's manned by basically nurses.
Yes,
Most of them. There are hardly any doctors there, and
exactly.
they do whatever they can.
Yes, exactly. that
Now
is-
in this tea estate, I do not know if there were doctors. Okay, you are trying to say that the hospital, there was negligence on the part of the hospital.
And they try
But
to
then
cover up.
for that, you'll have to say that the doctors did not treat them or there were no doctors. But the nurses were there. Are you trying to say that it was because of the nurse?
Were they, I'm just raising a question. Were they negligent themselves, the nurses, and they try to, because they are nurses, they are sisters. Are they trying? No, Lordship, because Lordship, but the thing is, here what we say is that the accused assaulted his mother.
Yeah.
Neighbors were not examined as per the cross-examination of IO itself and sketch map also. I'll show that Nobody said that they had any fight in the house on that particular morning. As per this person, it was in the morning. That morning itself, the son had.
Madam, if there is a, you see, if there is, this was an internal injury and there was a bruise.
Hmm.
Now to find out the real injury, the effects of that injury, ultrasound would have to be done most probably, or an X-ray. Something would have to be done. Just by seeing a bruise on your face or on your body,
Mm.
you cannot diagnose that this is a very serious injury or that is a very, because unless there is the wound is there's a cut wound or something that is pouring out. If you see a black spot, contusion, it can be it can be due to a fall, it can be anything, which might go away, the bruise might go in 2-3 days. So you don't really know.
So
So how can you?
So, Lordship, where is the proof that the accused gave those proofs? The accused, the IO says that he
The-
could not
The
identify the
mother,
place of
the
occurrence.
the mother said that my son assaulted me.
Mother said to these three, and they kept quiet. Lordship, they are saying that mothers told them that my son had assaulted me, so I was injured. That's what is the year, and they keep quiet till the
Madam-
mother is dead.
Madam, why
They do
not?
not even. They do not. even-
Madam, do you realize
Yes.
that there are so many injury cases all over which are not reported because you don't know that whether they are serious or not. Some might not be serious, some are serious. You see, there are husbands beating up wives every day, which are not reported. It's only when the death occurs that then it comes into a police case. Because I think 90% of the women don't report also. So, I mean, you cannot say that every instance of an assault, which only shows up as a bruise, will be reported to the police. It is not. You have got to look at the practical side of things also.
Lordship, then practical is also applicable to the accused. He
Correct.
gets the benefit here, Lordship, because prosecution has to, Lordship, I've given the copy, Lordship, about this dying declaration, what the, this is a very recent judgment,
Yeah.
Lordship, reportable notice that the copies are made, Lordship. It was decided on August 26, 23.
Yeah.
This is Irfan alias Nakka versus the state of Uttar Pradesh.
Yeah.
Lordship, I'll take Lordship to paragraph 62.
Yeah.
There is no hard and fast rule for determining when a dying declaration should be accepted. The duty of the court is to decide this question in facts and surrounding circumstances of the case and be fully convinced of the truthfulness of the same. Certain factors below reproduced can be considered to determine the same. However, they will not affect the weight of the dying declaration and not its admissibility. First, whether the person making the statement was in expectation of death. Lordship, here the trial court has taken the statement of the deceased made before the nurses as the dying declaration. But requirement of dying declaration is different and recording is also different.
No, you see, it doesn't have to be recorded all the time. It can be an oral dying declaration.
Yes, it can be Lordship, it can be oral. Uh, uh, I'll pick Lordship to section 32 of the Evidence Act. And along with these points, Lordship, of this judgment. Lordship, what section 32 says, Lordship, cases in which statement of relevant fact by person who is dead or cannot be found, etc. is relevant. Statements written or verbal of relevant fact made by a person who is dead or who cannot be found or who has become incapable of giving evidence or whose attendance cannot be procured without an amount of delay or expense, which under the circumstances of the case appears to the court unreasonable as themselves relevant facts in the following case. When it is relevant to the cause of death. When the statement is made by a person as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death. In cases in which the causes of that person's death comes into question. So that dying declaration has to be directly related to the cause of death. But if here, where the injury, where the assault took place, that that place is not identified. Nobody heard or saw that they're fighting. And also their relationship that they never had any fight with the accused and the mother, never had any fight. That is also brought in for family.
No, you see, what we're trying to say is that uh, there is no doubt. It appears that the son had assaulted the mother. No doubt about it. But whether the assault led to the injury which caused the death of the mother, that is a different thing.
So Lordship, once that
The assault is there.
Yes.
Assault is there because it is because the three nurses have said that there has been an assault. Now, whether that assault had led to the injury which caused the death of the deceased, that is a different issue. We do not know. Whether that spleen rupture and everything was the cause of the assault, that is a different issue.
that
That-
is
that
what
is
I'm
not-
harping on, Lordship, that the rupture in the spleen.
That is one way of looking at it. I mean,
Could the prosecution prove that he assaulted and it resulted in that rupture of the
that is one thing. Assault is there.
but in time about time declaration of it, paragraph 62.
And
okay.
another thing is that, of course, whether there was any intention.
That he got Lordship, please. That's not okay. Nine, the hotel is, I mean, they're thinking louder. Then Lordship, in that case, in judgment, Lordship 2, whether the dying declaration was made at the earliest opportunity. Rule of first opportunity.
You see, these are very subjective things because you don't know. You see, I'll tell you, like people who are, say, terminally ill also, who have cancer patients, they go for treatment, they come back, then they've got to go for after another 3 months, and sometimes after 6 months, depends. And sometimes when they go, some of them say that, no, now I have to go back. And some of them have an inkling that, they're not going to survive anymore. So there can be cases where initially the injury might not be such to enable to think that, that they would go away straight away. Because it takes time, sometimes, for injuries to really, manifest to a very serious state. So at that time when
I got the point.
when she
Lordship,
got
maybe-
the
maybe
injury, yes,
Lordship is saying that in the morning when she was assaulted, at
Ah.
that point of time, maybe she did not think that that might.
yes, when she was assaulted on 18, in fact,
Uh,
18, she went to hospital on
But
19.
they again in their research in the same morning. That
No,
is
no,
what
that-
164 statement, that
Ah.
contradiction is
Yeah,
there.
because they do not know anyway. So that can happen that she might not want to implicate her son at that time with the hope that she'll get cured and we keep it in the family. A lot of things are kept in the family. So not to spoil their name in the neighborhood or spoil the children's name in the neighborhood. There are a lot of say kids also who are doing bad things, like maybe doing drugs and all, and the family keeps quiet about it. Yeah. So, and
I got the point.
yes, so that's what I'm trying to say out here. Maybe she was trying to protect the child for the time being. But then
But maybe even she or
that is one way of looking at it.
if we even look at from the accused point of view, maybe he even didn't think that it might lead to.
Correct,
Lordship
correct,
is coming
correct.
to that
Yes,
intention, to the
Yes.
the intention, the menstrual.
Yeah, yes.
Lordship is coming to that, yes.
because there is no weapon, there's nothing. So, it can be a one-off thing. Maybe the assault may be a push, a heavy push, which led to the injury.
So maybe even light was because she was 50 plus age. So
Anything can
that
happen.
might also.
So that is one way of looking at it. Because if it was a real intention, probably there'd be a serious blow somewhere. But to have a blow here in your back, around your back area, I don't think that there was an intention to. It appears so that there was intention to do any real serious damage. Anyway, we will see. So that is one way of looking at it.
But-
I think that's, you're basically saying that section 32,
And also 291 culpable homicide, whoever causes death by doing an act with the intention,
299.
yes, of causing
So
death
no intention,
and with intention of causing such bodily as is likely to cause death or with the
no
knowledge,
intention proof.
the knowledge also. And if we go to 300 lordship, again, except in cases wherein,
So he'll have to be convicted under which section?
lordship. This one. What's the convicted like it?
Lordship, at the face of it, he might not have knowledge and the intention. It might be at the
Appears so.
spur of the moment.
Appears to.
And one of the factor in 313, he says, Your Lordship, answer to question number 12. He lived with his mother prior to her death.
He?
He lived with his mother. Answer
Correct,
to question
correct.
number 12.
Ah.
So he ought to give an explanation under 106, my lord, under what circumstances she died. And see the Lordship condition of mother was ailing or whatever she got injury. He did not do anything. She had to call one of the neighbors, PW1, for ambulance.
It's a line to it up because
Whatever
he
may be.
gave that explanation, lordship, because I had gone
Later
through-
on, while shifting, he has taken steps. But at on the relevant point of time, when the injury was,
Maybe at that time, it was at night,
At work, lordship.
maybe at night, 18 night. And night time, so maybe he thought she'd get better. He went off early morning to work and then he's not feeling better. So it happens sometimes that a neighbor can be called to do the work, you know. And so there are many different things to look at.
but is oral dying declaration given to those two witnesses?
Uh-huh.
Lordship, why to disbelieve them, my lord?
Yes. No, but then does it, can this case be said that, can it come under 302?
Yes, so I'm thinking, Lordship, I'm making the submission. It may be a case which can be brought in under general exception. 304, part 2 or 1. Knowledge and intention is not there, 2
30?
304, part 2, man.
Let us see 304 part.
04 part 2, or with the
Culpable homicide, the punishment for culpable homicide, not amount to murder.
But there might not be any knowledge also.
no.
Where is the knowledge? How do you say that there is knowledge?
But
Might not-
intention is not there. When intention is there, then it
Intention is
will
not
come
there.
under 304 part 1.
Ah.
When
So
it is
no-
not there,
But knowledge also, how do you say that there's knowledge? If there was knowledge, then he would have taken her straight away to the hospital on the first day itself. He did not have fun.
because he is the perpetrator, my.
No, but
he did not
still,
inform.
how do you prove the knowledge? Just because there was an assault, doesn't mean that there is knowledge that that
But
person is,
because of the injury caused by him,
that is likely
the
to cause
victim
that.
died.
No, maybe. But then how can you say that there was a knowledge that the injury would likely cause that?
Let
It
us
is
see the
benefit of
exception.
doubt, lordship.
Then it might have to go to a lesser charge, maybe.
Yes, my lord. So lordship, since the person has died and
Previous
your
one.
lordship, it's a exceptional case. Son being killed, the mother being killed by her son, my lord.
So which provision of law?
Prisoner for part 2.
Is there a
Yes, your lordship,
Part
come
two.
up on that.
Part 2 will be knowledge.
Is the knowledge? I don't know if there can be knowledge. I can
Lordship,
understand
others
if,
are-
yes.
yes.
I can understand if he hit her on the head with a bamboo stake or with some piece of wood. But when there is a contusion on the back, say a bruise, a punch. How do you know that it will be like, it will likely cause death?
No, it's internal,
That's
internal.
what, how do you,
injury, yes.
that's what,
So from the postmortem report, your
no, no,
lordship.
that is all right.
Yes,
But
my
for
lord.
the person who assaulted the mother, how would he have an idea or have a knowledge?
Then without this exception.
If the
it's
otherwise-
More than 326.
Huh?
323 lordship. 326 also was the 323 punishment for voluntary causing hurt. Whoever except in the case.
No, no, it is the previous part. 326.
No, previous he was there for only 1 day. 1 day. So previous hurt we have to
320 voluntary causing previous hurt.
for 1 year. He has already stayed in
Voluntary
one-
causing grievous hurt will be how much?
one year,
Maybe 7
year.
No, 326. Lordship, probably it will come up under general acceptance reserved for part 2.
04 part 2 lordship is extend to 10 years. There is that is the maximum. So
Maximum,
lordship,
yeah.
then he has stayed for 1 year lordship that even
One life is gone.
that is true. He has lost his mother also, but he never tried to. I don't see. I mean, even touching the paper book, I do not feel that he wanted to kill his mother.
Lordship may see the injury, page 66. Contusion of size so and so over left side or upper part of abdomen.
So there are two injuries.
True lordship. That is
Abdomen cavity contain blood. So if the blow has been given, it was lordship serious in nature. This was full
Yes,
force.
it was obviously in the vital part of the body.
Yes,
So that caused the confusion.
Yes.
Confusion is apart from confusion,
lord.
there's the blood in the cavity.
yes,
That part, the screen was ruptured.
my lord.
So the force he applied was a really.
Lordship.
So that is the vital part.
it might be lordship. Then he might have fallen back or
There's no
Maybe
such
Well,
thing
that's
as
all,
such.
that's all.
No,
Actually,
because of his foot, I'm not saying
Wait,
on her
wait.
own. So, though in cross-examination, that is put that it have the doctor itself, screen rupture may be caused by falling on hard surface.
Okay, I think we have heard. I think
304 part 2.
304 part 2.
And time under that 1 year.
Only
something
1
that-
year. I thought, good thing, your lordship, 2022, date of commission of crime, 2023, the matter.
No,
was come up like this.
I request that the
should
case may be
appreciate
heard
it, madam.
because if he gets an acute lordship, why should he language with the
Well, it's
case?
good.
Because
that
1
the
month back,
system has
the
been,
case
like,
came up.
progressing
then
well.
I requested the court that the case will be listed. Because if he has to say, then okay, lordship, let the court take time. But when limited that, I felt that he might not get the life. thing.
That he took the mother when she was shifted to that.
Is
That
it there?
evidence
No,
is not
it-
there.
it-
Part 64, it's
No, no,
there.
he's
One,
313,
313.
313 only he stated that, but
Yes,
no
But
evidence is there.
no,
that
no,
he
no,
took
no,
her mother.
even the witnesses don't say they do not reveal who
He said
took.
referred, she was referred to that one.
Yes, but he
So
took.
under reference, but he was not there. It's
No,
not-
no,
There's
he
no
took-
evidence.
No, like the question
Evidence
four,
is not there.
Question for his reply
Statement.
only, his
Huh.
statement.
that
No
is his
evidence is there
explanation,
that he was there. From the nurses or whatever was there, there's no evidence about that he was there in the hospital and he also accompanied his mother to that hospital. That is not. it is his reply that, yes, I also.
But
went.
lordship, prosecution has to prove because it
Lots
is
of
always the
prosecutions are there.
prosecution will, defense
lots of-
doesn't have any, even if he doesn't give a reply to this, we have to see whether the prosecution proves the case that about it.
This witness, my
Okay.
lord,
I think,
one Mamoni Saikya says that from the ambulance driver, she has come to know while shifting later on, she has expired in page 85. There's no mention about that the accused person was affected. 10 years, my lord, he killed his mother. Lordship,
Ah.
minimum 10 years because
No,
lordship.
maximum is
no,
10 years.
maximum is
No,
10
what
years.
I-
30 for part-
What I'm saying, my lord, because it's not an ordinary case, your lordship, a son killing his mother, my lord.
No, lordship,
So your
in
lordship
an
will not take
ordinary
into-
situation, a great thing happened. It was an ordinary situation, lordship. In the
Mattress, a case of mattress right now.
people,
We will decide.
Yes.
Yeah.
We'll decide.
I had another judgment also, lordship, to
Okay,
create your
yes.
knowledge that about that mere suspicion and case as a. which is-
Acha, there is one thing, actually why I'm in a hurry is that at 3 o'clock I've got another DP.
Yes,
Yes. And bail matter.
Yes, Mr. Patu, yes,
Acharya.
no, the, yes. 3 o'clock you all are ready?
Yes, yes.
You all are ready. So I hope we can we complete within the 1.5 hours, 1 hour 50 minutes? Huh? Can we complete? You say no, he's saying no. Yeah. Okay. Right. Heard. Ms. R.T. Mazumdar, the Michael student, and Ms. P. Bhuyan, additional people. Hearing concluded, judgment written.
Value of time.
Yes, yes, come.
I have found two Supreme Court judgments, but I have said about.
And Supreme Court has got power. Not like us.
Yes, yes, but here was the sentence was not suspended, only interim, on an interim you are basis to perform the last. First, your lordship will find Hari and another. And second is lordship that Sanjay Chandra. Last page of last page.
This is with regard to what, a contempt case, civil appeal.
No, here in last page, your lordship will find one
This
criminal.
is
was
a
also-
civil appeal, this is not a criminal case.
I think it's a case of.
No, the lordship may kindly see the last page. Here,
Yeah.
the order was passed in that SLP criminal against conviction. It was checked with that criminal. And the other case which I have given, Hari and another, this is against conviction in the first line. The appeal filed by the applicant, Dharamji, against the judgment of High Court affirming his conviction by the Sessions Court under section 30
The appeal filed by the applicant around.
is pending consideration.
Supreme Court has got a lot of power there.
I'm only for a fixed period, only to perform the last. After that, if you want to fix a very particular case, you will start.
No, and no judgments by this court. What high court?
I have not
Can it
any
be
other
taken
high court. I do not want
Oh,
to
your
burden on your lot.
No, no, show me this high court judgment.
Because I have not printed it out, but other high court judgment.
No, no, this high court judgment.
I have at the single bench judgment is
No, because it's going to become a.
on single bench judgment, but I.
Huh?
The single bench judgment, so your lottery is not gone, but I have just hurriedly got it lottery. So I'm just.
But then.
Lordship,
any
may I take the lordship provision under 29?
Yes, yes.
Okay. Suspension of sentence pending the appeal release of appellant bail. Pending any appeal by convicted person, the appellate court may, for reasons to be recorded by in its writing, order that the execution of the sentence or order appealed against is suspended, and also if he is in confinement, that he be released on bail or on his own bond. Provided the appellate court shall, before releasing on bail or on his own bond, a convicted person who is convicted of office so and so, date imprisonment life, public prosecutor should be given that. So let the matter be taken up tomorrow, but tomorrow your lordship won't be there.
Tomorrow I will not be.
Only for temporary basis, not.
No, no, Mr. Council, it's not that. You see, the thing is that. Once we pass an order, you're going to ask in similar matters. Also. Now we want to ensure that the order is correct. If we have got the power, no problem. But if we are giving an order which is not correct, then we will be starting a wrong trend.
No, lordship may observe it that about 7 days or 15 days without exception. I am not coming for extension. It is
No,
only
it's
for-
not an extension, Mr. Council. This the question is not with regard to extension. This is,
Last hour they have come, your
yes,
lordship.
you had so much time to come also.
13 days.
The question is more on the side of being, being careful so that a wrong order is not passed. It's not that we want to deny you your application. We want to give you your prayer. However, it should be lawful, it should be correct. That's all. It's only on that ground, because otherwise we will start a wrong trend. Illegal trend. So that we want to be careful with regard to that.
Lordship will go into the legal aspect. If he has got urgency, he has to raise the concern for listing it tomorrow. This bench won't be available, but some
He
other
can
division
list it
benches
to-
will be
he can-
available.
Some other criminal bench is there.
No, it's not there, but some other division benches will be there.
But there have to his application is appealed. I am not saying that.
Why don't you go to the IGP? The IG
It
present.
will take time. That is the problem. Because they have to call for records, they have to obtain instruction, and I have to come.
And
to
why
the
did
date
you
of-
come in the last minute? Then?
I have
Your
been
your
informed
father
last-
died 10 days ago.
No, I
Why have you come now?
I have been informed lately. Because otherwise I was.
You didn't know that your father expired.
No, I was not informed. As a council, I was not.
No, no, that is a different thing. Where are you put which jail are you there?
Tiran,
Where is Kerang?
Kokrajar.
Kokrajar. And where is your residence?
I am resident of Iran.
Kiran.
Iran, there is no central the jail losses, so the inmates are kept in Kopragar
How far is that?
nearby. But
So let the jail authorities take you
This
to
side.
to the place. We direct them. No bail. And because we want to clarify this, otherwise we would have granted.
actually directing the jail authorities.
To take you to your residence
That will also do.
on 30th. From what time? From 11 o'clock. When will you start your program? What time?
Probably 10.
Probably 10. So we start from 8 to
3 or
8 to 3, 8 to 3 o'clock. And please don't come at the last moment and some other day, if you can show us the law. Even if it's some different case, so that we get prepared. Otherwise, you come at the last moment also. Otherwise, if we were sitting tomorrow, then we could have done some research.
I actually mentioned yesterday, and it was your lordship has allowed my mention.
Ah.
But instead of that, my matter was not listed, so I have to meet for potato. Yesterday, your lordship allowed. Otherwise,
Okay,
your lordship would have come.
Heard, Mr.
Yeah.
A. Ahmed, Learned Counsel for the applicants who submits that the Shraddha ceremony relating to the father of the applicant number 4 is to be held on 30/09/2020. He accordingly prays that interim bail may be granted. Interim/conditional bail may be granted to the applicant number 4 to enable him to participate in the said Shraddha ceremony. How do you spell? PHYA. Ms. B. Buyan, additional PP. Submit that the question as to whether the submits that the sentence given by the learned trial court would have to be suspended. Correct. Would have to be suspended prior to allowing the applicant on bail.
Lordship, I say wrong in submitting
Okay,
without going
where-
to the.
Okay, no, cut that. Just say that. Ms. B. Buyan, learned additional PP submits that the applicant number 5,
Oh,
4 can be taken to his residence for performing the said ceremony.
My submission is he may approach the jail authorities.
Okay, Ms. B. Buyan, additional PP submit that the applicant number 4 may approach the jail authorities under
Under lordship,
what rule? What is the rule?
under Assam Prison Leave and Emergency Release Rules, 1968.
For release on conditional bail to enable him to perform the ceremony.
Conditional release.
Conditional bail, actually, release has to be on bail. Conditional release on what? It has
Because of
to be-
emergency in
Okay.
situation.
Okay, conditional release. Next, Mr. A. Ahmed
Second to one.
submits that. The applicant would not be in a position to approach the authorities in time, as tomorrow is a Friday and the ceremony is to be held on Saturday. Next, in view of the facts and circumstances of the case, this court is of the view that, no, before that, you're right. On perusing the application submitted by the respondent number 4 and other convicts, praying for suspension of the sentence passed by judgment, passed in the judgment, passed due to the judgment dated 30/1/23 by the learned Sessions Judge Tirang, Kajal Gaon, Assam, in Sessions Case number 8/2021, by which the applicants have been convicted under section 302/34 IPC, we are of the view that the prayer of the applicant number 4 for conditional release of bail cannot be decided at this stage in view of the application having been filed only at the only on 27/9/2020. Thereby giving no time to the additional PP to submit a written objection. On considering the above fact, we are of the view that the special superintendent or superintendent, what is that? The superintendent of the
district jail, Kolkata.
of the district jail, Kokraja, shall arrange an escort party to take the applicant number 4, Shri Bikram Khalko, to his residence for participating, to enable him to participate in the Shraddha ceremony between 8 AM and 3 PM. A copy of this order shall be furnished by the applicant to the concerned jail superintendent for compliance.
One more. Lordship, jail authorities, it should take adequate steps. Lordship, then accused may convict me.
The jail authorities should take adequate steps to ensure that the applicant number 4 does not abscond during the time he is out of the jail premise.
At 8 AM to 3 PM on 30/09.
8 AM to 3 PM on 30/09. All right.
That will, I could not, but I just making on prayer. But if I get the copy today, Lord.
We'll give you. It'll be uploaded.
I could
That's
not
why,
just,
we have not said certified copy. We have just a copy of the order. All right.
but just to discuss the about last occasion, we covered the submission. The last occasion. Before you said-
Yeah.
No, but- We summed up the submission that the appointment to the post of protocol officer was a substantive one. And that was the appointment made by following the due process of law. And on support of that, we placed the decision of Balak Shakar. There are other divisions also, which we like to refer. Well, the short questions that have been argued in this particular case, and which is the sole contention of the repetition. What should we find? What is the foundation of the petitioner's case? Let us profit from that foundation, not beyond or not on something which they never argued. As I submitted on the last occasion, they were trying to dig up certain facts that in 2011, some procedure was thought to be followed and which was not fructified, and therefore in 2014, the judges committee decided, and according to that decision, it has been followed. Post of PO, that PO have been filled up. And that is the foundation. Nobody challenged that procedure. No challenge was put to that advertisement whereby options were asked for. Rather, everybody participated who opted for. Selection was done and the appointment was ultimately made. That appointment was never put to challenge. Not only that, the advertisement, which was the foundation for the entire recruitment process, that was also not put to challenge. And also the fact that appointment to the post of PO was also not. Having accepted that, the ground urged is that I am not eligible and not having qualification for the post of secretary to the other person. That is the point.
No, so according to your appointment to PO not challenged,
Not yet.
but appointment to PO is only temporary. Order.
They now come up. They now come up with the interpretation that that is only temporary. So I could not have been considered for further appointment
Promotion.
to the post of secretary to the.
So
But-
what,
But
so what do you say to that?
but I'm coming. But what you will kindly notice that his appointment as such was never put to challenge. That's all, he could not have been appointed. The process is bad, or that that appointment is bad in whatever form it may be. That was never put to challenge. Now the issue arose when I was appointed as the secretary to the Chief Justice on officiating cost. That was there. The point has been urged that I could not have been considered to the post of secretary because number one, they say that I am not eligible. Why not eligible? Because I was holding a temporary post in the PO. Fact remains that person who is holding the post of PO otherwise comes within the pool of officers eligible to be considered for the post of secretary.
But it would be only the regularized
Exactly.
person.
Regularize those who are substantively appointed to that post.
Correct.
That they are eligible. So they took up the point that my appointment was not substantive. That is your temporary. Because they went on the particular clause in the appointment letter also that my seniority is to be reckoned for further promotion.
No, and the order also says temporarily appointed.
That temporary word is used,
But
practice is right. That word temporary has been used in the
appointment order. But as I submit on the last occasion also, this is in an ordinary form of appointment where it is mentioned temporary, but it does not. And by itself, it cannot be construed that the appointment is temporary or purely temporary. That is not the yardstick. That word is not the yardstick to construe it. That the appointment is temporary. Fact remains, Lordship will kindly take note of. The Palestine Assess case that was placed on the last occasion. What they have seen, interpretation was given that even there can be substantive appointment to a temporary post if it is so provided in the cadre. In a particular cadre of officers, there can be regular vacancies.
No,
regular posts
substantive appointment to a temporary post.
can also be made. That was the interpretation given by the apex court.
But then the then, but then that's different from the issue here.
Well,
Out here,
Yeah.
it's a temporary appointment to a
now
substantive.
my question is, just to appreciate that, Lordship may kindly consider to appreciate the fact when a particular appointment can be considered to be a temporary. In that sense, according to the apex court decision, my argument is that if a particular post is, for argument's sake, let us take it temporary. It is not in the cadre. Not in the cadre, it is a temporary post created. That temporary post continues for an indefinite period, longer period. And persons were appointed to that post by following a process of selection. That is a temporary post appointed in substantive capacity. That is
What was the temporary post?
temporary because it is not in the cadre. It may be retained, it may not be retained. It's temporarily created, temporarily.
Which post?
An example I am setting.
What example?
An example I am setting. Here, that is why I am saying, well, here in this case, this post is a regular post, permanent vacancy. It is not that it is a temporary post, a cadre post, not in the rule, not that. So the cadre post, substantive vacancy. Substantive vacancy was filled up. In the advertisement, nowhere it is said that a temporary post is going to be filled up.
No, there is no dispute with regard to that.
Exactly. Now,
But
Now
what they
therefore-
are saying is different. They are saying that the cadre post has to be filled up on a regular basis.
regular basis,
So it was not done.
regular basis, this post has been filled up. EO, not even kindly take note of it. EO has been filled up on regular basis,
No,
but in the
uh,
appointment order, that particular word is used temporary.
no, besides that, now supposing, let us take a situation. When you are promoted to a post from AE to EE. Person is promoted to the post of EE, does not say that your seniority will be as per your position as a AE.
Yes.
It will be in the E. So why is it here not made that he is
That is, well, I'm grateful. What is the troubling point here?
Yeah.
Troubling point here, whether that incorporation of that particular clause that my seniority will be counted.
that condition?
Condition, that condition put there, that in the lower cadre, I mean, in my original post for further promotion. Whether that has any sense, that has any connotation in this particular point.
That is what the single judge has said that.
Single judge has said that, yes, this has the connotation and that the single judge has interpreted it, that is a temporary appointment because this condition will be there. And we have challenged that particular finding of the legislature on the ground that it is not the criteria for deciding the sort of appointment to the post of PO. If the post is regular vacancy, if the process is followed, due process was followed, the process which was holding the bill, the particular rules regarding or the instructions regarding the recruitment process was followed, those were scrupulously observed, and thereafter appointment was made, then in the appointment letter, if certain conditions are used, incorporated, which have no backing of the recruitment rule or the instruction, then this cannot at all prevail and cannot be construed that by itself it will not make the whole appointment temporary or not substantive. That decision I would like to place ballot. That decision, the apex court has said in several issues that if the whole process of selection and the nature of post and the nature of recruitment is substantive, then incorporation of certain clause which goes against that particular concept is immaterial. It cannot change the nature of it. It cannot change, alter the nature of appointment, or it cannot dilute the very nature of substantive appointment to the. Therefore, now, Lordship may kindly recollect, the argument at front or the point taken by the registry officer of the court is that was a substantive appointment to have, because he was treated to be a member of the service. When he becomes the member of the service, if a person is duly recruited to that post,
Okay, in that case, the subsequent appointment as secretary to the CJ, that was on a temporary basis earlier, that it was,
Yes,
then
initially official,
it was temporary.
official.
Then why was it regularized?
That regulation, that is the reasoning given. How it was regularized and why regularized. In the case of secretary, not in the protocol.
That's what I'm saying.
That is
No,
not-
what, you see, what Mr. Mahanta is saying is that the word temporarily appointed and that his placement in the seniority list in SJ will be counted as given in his appointment letter order as PO. In effect, does not have any meaning as his appointment is on a regular basis to the sector. So there is no, use of those words temporary and the counting of his seniority as SJ does not mean that he is on a temporary basis.
I'm guessing. That is what.
That is what you said.
Okay.
Now, in that case, that same analogy would apply to your appointment as secretary to CJ.
No, in my
Why?
response, let me clarify. When I was holding the whole factual aspect and the clarification coming from the registry, that he was holding a substantive post as PO. Therefore, when the question of appointment to the post of secretary to the Honorable Chief Justice arose, that time, going by the provision of the rule, we have placed all those officers, credentials, that biodata before the appointing authority, who under the rule come within the pool of officers, that is the zone of police. So, meaning thereby that since 2C, I am also in 2C, I am also in 2C as PO, holding a substantive post. Therefore, my case was also along with other all eligible candidates placed before the appointing authority for consideration. The appointing authority out of the pool had chosen me and appointed me. But
On
My
temporary
appointment was
basis,
made on officiating way,
officiating basis.
officiate,
So
temporary, officiate,
what is the word used in the order?
officiate,
Officiate.
officiate. That will not you will find at page. That page 146. Regular, regular. 145. 145. Annex F.
One forty-five.
Reasonable five, my lord.
Reasonable one.
Reasonable five.
One forty-five.
145.
No, outside it says temporarily. Doesn't say officiating.
No, it says, madam, page, third line, page 145.
Yes.
Is so and so, Nirut Sharma, protocol officer, temporarily and until further orders as secretary to the honorable CFC on officiating with.
Non officiating, temporary. And let us see your appointment order as PO.
Three page, Lord, we find the 144, page 144.
Temporary. Okay.
Therefore, my lord, mere use of the term temporary, my argument is, cannot render the appointment temporary if otherwise it is found that it was a substantive post and was filled up on regular basis. Therefore, the last paragraph of that appointment had no connotation. Probably that would have come to the effect had I been sent back to my original post. Then the question of promotion would have arisen there. Then, of course, things would have been different. But so long I was holding the post of PO, it was on substantive capacity. I was a member of that particular service to see. And therefore, I come within the zone of consideration. And my case was also placed before the authority. Therefore, their argument that I was not eligible to be considered is unfounded. That I was not eligible to be considered, that is not founded on any factual basis. Rule says that a person holding the post of PO to say is entitled to be considered for the post of secretary. So the rule has been said. Question has read the rule.
Now, one question, once you are regularized to the post of secretary to the CJ. And if he does not want you, after some time. Then what happened?
Then he will be sent back, reverted back to the protocol officer.
How can he be sent back when he's regularized?
That is, well, when regularized, there is no question of sending back. If you not have been
Now
regularized.
let us see again
If you put.
let us see again that 144 and 145. Yes. 144.
Yes.
Is to appoint so and so temporarily as protocol. 145 is temporarily on officiating basis as secretary to, okay.
Right.
Then 146 is to regularize the appointment.
Yes.
As secretary.
Yes, yes.
Now the question arises. If now he doesn't want you any longer after a few months, then what happens?
Then any post, if protocol officer or any equivalent post in that particular quarter. So instant rate.
Huh?
It is instant rate.
Now let us see this WA 71. What Act. Grounds on which the conclusion decision of the single judge is assailed. In page 22. B. At the bottom. Laid emphasis on appointment to the post of secretary to the Chief Justice on ad hoc or temporary basis and not on permanent cadre. And not on permanent cadre. What does this mean?
That's it. Well, to my understanding, till then, when he was in officiating. the post-
No, so this appointment is not on not on is not on a permanent cadre. What is this?
We have to bring all petitions. This was a view of 2003 by the Honorable Chief Justice then.
No,
2003.
look, this is an appeal. This is part of appeal filed by you
I understood. Why not we
in
not-
23.
Ah.
So this is a ground taken by you.
Why not, this is a appeal, this is a note given by one of, because this is one of, help, we have produced the record. One of the people that has produced it, then my lord would see the conclusion. Why we said, we had to, one of, there is one factor which I think my lord combined, just. Let's see, I'll elaborate with that also. Why not we only look into this factor, how it stands. There is a post of protocol. At one point of time, there is no rule. The rule does not apply. One point of time, the judges rule that we will make promotion to the post of assistant protocol from waiting or anything, and from assistant protocol officer to protocol. This was the system at that one. It was once or twice was done. Subsequent, there were representations of the association. Then why not again a review happened. This time it was said, look, we will fill up the post by way of option. So promoted on option from whom? From SJ who have completed particular year of time. And the assistant protocol officer would be filled up by way of promotion, by way of option from the J. Now options are called for. These are placed before the company.
The pay scale is
Higher.
Higher.
I'm coming to that. I'm coming. The options are called for, and these options are placed, the person who are placed before the committee. The committee then forms a subcommittee of judges to carry out an interview. Markings are done. Then recommendation. It goes back to the committee. In the process, my lord, there was a fear raised that people are going, because protocol officer, nobody wants to go. There are very 100 out of 100 maybe 10 opts. So other 99, 90 does not want to go because of the nature of. So they don't go. These people come in, they offer. And then my lord, the recommendation is made and appointment. Now while making that appointment,
he is not there with a charge allowance. My lord will see, when a man officiates in a higher post, he is given a charge allowance. Say, I am a LDA, I am officiating as an UDA, I get 49C, my lord. So this is not a situation under 49C. He is given this case, plus a gazetted staff. So till the time he is there, he is an incumbent in the post of protocol officer, a member of the Guwahati High Court service under 2. Till he is. Because there is no other way prescribed for filling it.
Okay, then.
Then.
Then,
There. My lord, tomorrow, why that rider is? I'm coming to that. Unfortunately, it's the creation of the High Court. We can't say this is how it wanted it to be. Now, the administrative committee, whilst doing it, found post of court master. There is no promotion there. If it is given permanency without amending that rules there, they'll remain back here. Now, to obliterate that,
court master, or court officer.
court master, not court. Court officer is a regular. Court master, my lord, he is a gazetted officer. Till he holds that post. Now, tomorrow,
No, court master is with the protocol officer and it comes under 2C.
no, it's below 2D.
Court officer,
Court officer is there. Court master is
court officer is in 2C.
2C. Court officer is a regular.
The court master is in.
Yes.
So why are we going into?
What I'm
court
trying to point, because this was the analogy that was put. I'll show that. Then tomorrow, because he is there in SHA, senior judicial assistant, he'll be coming up, he'll be doing work of protocol. He'll become an AOJ. His turn will come for an AOJ, say after a few years. He'll be, if my lord, he remains here, he'll not be promoted
If he
as,
remains as what?
if he remains as protocol officer, because there is no further promotional revenue given to that.
But it is there in 2C, protocol.
2C, only 2C, but no promotional revenue. It's an independent post, no promotional revenue has been given. So he becomes AOJ. Then tomorrow, my lord does not want him. Want somebody else, because he may, work may have fallen. My lord can adjust him as AOJ. So it is for to protect him from the adverse consequences, because he will do adverse work as a protocol.
I don't find the connection.
My lord, that, because otherwise there is nothing to say. My lord, otherwise there is nothing here which says that while he is as a protocol officer,
No,
otherwise, my lord, how can
no, I'm not on that. You see, out here. In your page 23
lordship,
of your appeal,
lordship,
it basically says that
Huh.
the appointment to the post of secretary to Chief Justice on ad hoc or temporary basis
lordship,
and not on permanent cadre.
from the,
So it is
for
not
that
a-
the learned,
it
so,
is-
my
it
lord,
is-
we'll have the whole paragraph,
Yeah.
what I'm trying to say.
Yeah.
For that, the learned single judge although considered the original records of the case,
Yeah.
however, did not appreciate that the then Chief Justice on so and so in the administrative side laid emphasis on appointment to the post of secretary to the Chief Justice on ad hoc or temporary basis and not on a permanent cadre, so that if the Chief Justice finds the incumbent to be not to his expectation, he can be relegated to his post from which he was promoted temporarily or on ad hoc basis. If permanent appointment is made to the post of so and so, the Honorable Chief Justice would not be able to remove him
Remove him.
if he lost confidence or if he found him not to be trustworthy or suitable to hold the post of secretary to the Honorable Chief Justice. Therefore, the Honorable Chief Justice should be given absolute discretion to appoint any suitable person to hold the post of secretary to so and so, and the Chief Justice shall select any person from the High Court service for ad hoc, on ad hoc or temporary basis, cadre so and so. The aforesaid decision
And
of these,
the person shall be reverted back
fine, fine, ma'am.
to his
the-
parent cadre if the honorable finds him to do unfit.
fine.
So basically,
My lord will not,
Yes.
my lord will put.
Yes.
The opposite decision of the then Honorable Chief Justice demonstrates the absolute discretion enjoyed by the Honorable in choosing his secretary. Even assuming not admitting that such discretion does not appear to be unfettered, however, taking into consideration the job responsibility attached to the post. The decision culminated upon in exercise of such discipline cannot be termed as erroneous. However, the Honorable Single Judge did not appreciate such significant aspect of the matter while denying one. Hence, on this score alone,
So,
then my lord will have, no, my lord will, because
Every-
this was one of the,
no,
no, no,
what, no, please try to understand. Look, I'm listening to you, don't worry. I've been listening to you, please listen from
Lordship.
my side.
I'm here to clarify.
Now, this paragraph B from page 22. Basically, I mean, to our limit and understanding,
Lordship.
is that this should not be a permanent post.
Hmm. Hmm.
It should, I mean, and it cannot be a permanent cadre. It is only at the pleasure of the Chief Justice that this post should be held
Lordship.
for a person
Lordship.
who, if once the pleasure is goes, then he goes back.
Lordship.
That is what you are saying in this para.
I'm not saying that is what my lord the record says or opinion.
No, so
Of opinion.
Ah,
Because the Honorable Single Judge has traveled to that extent that I have to clarify.
okay. No, so what else? So this is your
This is
your
an
appeal.
opinion of 2003 by
Ah.
one of the Honorable Chief Justice then in office.
Thereafter it has changed.
It has changed.
Okay.
It has been evolving, my lord. Like protocol officer thing has been evolving
Okay,
This has also been
let us
evolving.
see where it has evolved.
because, my lord, the person just before,
So let us see where it has
Mr.
evolved.
Silent Chaudhary, my lord, why come to Niroj Sharma? Silent Chaudhary, the person just before the incumbent, he was a regular incumbent in that post. Then he was promoted as deputy registrar, my lord. From that post, he went as deputy registrar. So it's not for the first time that in case of Niroj Sharma, this was done.
No,
was-
I'm not on that, whether it's the first time or second time
Gotcha.
or third time. But this is a stand you have taken in your appeal.
That is a stand which was there.
Is
in
it still there?
2003.
Is it still there?
It's not there.
Then why have you put it here?
Because the Honorable Single Judge had taken a recourse to that. I had to clarify.
Now, just please clarify then, this page 22 and 23.
I'll do that. I'll do that. 22 and 23, I'll clarify. Further. When my turn comes, I'll not leave it blank. I'll come to you. Don't worry. I have to. I have to. Madam.
I'm not worried.
I am
I'm
worried.
not
madam.
worried.
I am worried.
You
because
should
my
be
action
worried,
is
yes.
under question. Because it's my action that is under question. I
Correct.
have to be. Madam.
Correct.
I'll have to be. Madam. Some words come out sometimes. But it's
Yeah,
not
that doesn't matter.
My lord, the only thing my lord would have to look into is whether the question here is whether it's not whether his substantive appointment there is a officiating there, that's different. Whether he could have been considered for that. Offset.
No, that is, you see, we cannot limit ourselves now.
No, first question first.
Yes.
As per subject to what my lord would say. First question first is whether he could have been considered. The case of the petitioners was he could not have been. I say, which my lord unfortunately did not find favor with the Honorable Single Judge. My case was that once you are in the cadre of protocol officer, you are in 2C, Guwahati High Court 2C service for all intent and purpose. If you are in 2C, you come within that. And you can be considered by the people. First, the Chief Justice appointed him in the note as on official. 2 years, my lord, he was there. Thereafter, a detailed note, which my lord would find in full, my lord, it is extracted in the charge. It's extracted in the charge. Wherein, my lord, everything has been dealt with. Why he should be regularized. Because, my lord, this post,
I'm not on that.
because my lord's question is,
That question will come later. That's a different issue.
my lord's question is whether that post of incumbent should be placed there on regular basis. The rules as it stands today, it's a regular post. It's not a ad hoc. post. There may be ad hoc appointments.
So the question that comes is if it is a regular post, would it be proper for exercise of discretion
Yes,
and doing away with the educational qualifications required?
Lordship. Lordship. First question first. The plea taken is the arguments of the petition. Is that this is a promotion. The post of secretary is a promotion. Unfortunately, it's a post, direct recruitment post from in service, that pool.
That is something we'll have to see, because according to the petitioners,
Lordship.
it is a promotional,
Let them show, my lord, where it is prescribed to be a promotional post.
it is a promotional.
It is
Ah.
not a promotion.
Then according to you,
It's a,
it is not a
it's
promotion.
not a promotion.
Then
It's a post wherein, my lord would say, this post-
it is a post to be filled as per the pleasure of the.
No.
As per the discretion of
No.
the,
It is a post which is to be filled up, considering all the incumbents which are mentioned in 3A.
3C, 2C,
uh,
2C.
No, 7-3A. There is the services given. All the incumbents in that service, all are placed before the Honorable Chief Justice with the materials. Then the Chief Justice chooses as per his sole discretion, because the rule is very specific to that extent. The rule says 7-3A,
So first of all, according to you, it is a regular sanction post, correct?
it's a regular sanction. Secretary
A
to shall be
regular
appointed
sanction post which should be filled up,
from,
which
by
should be filled,
considering,
which should be filled up.
by considering all
By-
the incumbents
All the
in
income-
class 2AA, class 2B, or class 2C.
in terms of section
7-3A,
capital A
capital A,
of the
of the Guwahati High Court rules, service rules, 1967.
1967. Now,
Considered suitable by the Chief Justice, having a lottery.
Huh?
Having a lottery. It's there. How can I go beyond that? It's there.
considered suitable by Chief Justice,
Considered
having
suitable by.
law degree.
There is no other parameter.
Now, but then this requirement of a law degree can be done away with in terms of 63A according to you.
My lord, 63A is very specific. And this is within the rules. My lord. This is not beyond the rules. The argument sought to the advance was that the discretion exercise is beyond the rules. No, it's within the rules. And my lord would say, unlike other rules, here the prescription is the Chief Justice shall have the power to relax age or qualification.
Okay, no, we're not on that. I'm on a more, on a different thing.
Lordship.
If there is a regular sanction post, and if a person is appointed to that post, according to you, he goes into that cadre, that grade, and there's no question of coming back.
Until and unless he's regularized. No,
Naturally,
okay, fine. My
Naturally.
lord, I take my point.
now that post, it is a regular sanction post, can be filled up in terms of 63. And that is what I think, can be filled up as per 63.
No.
And 7C. 7CA read with the 63. Naturally,
63A would come in, my lord, if there is any lacking.
naturally.
63A would come
So according to you, now this case, he comes under 77CA. And also,
He is-
and also because he's lacking in this law degree, 63A has been applied. So 73A plus 63 has been applied. So it can be done according to.
And that is exactly
For
what
a-
is said in the.
Now, so that is the question, that has to be decided as to whether a regular sanctioned post can be filled up by way of applying the discretionary power.
My lord, this discretionary power that is being given, it's unfettered. It's unfettered.
Now that is what this, okay,
This discretionary power is unfettered. It's the sole discretionary power given to the Chief Justice. Under the rules. And this is never under challenge. Anyway,
so can you have some unfettered
yes,
discretionary power?
yes. Now, how tomorrow, well, it will already decide that any action taken on the administrative side, in the judicial side, it can be. Now, I, as the honorable, as a Chief Justice, exercise that. Now, when I'm exercising that discretion, I'll have to give it. There are powers of the Chief Justice wherein he is not even required to give it. It's explicit. But here, it's not excluded. He has to give. Now, that reasons he found germane to the, I think, nexus to the object should ought to be. My lord will not interfere in exercise of religion. My lord finds it to be utterly malicious, having got no nexus with the objects of the being. My lord will surely.
You know, I was looking at a hand movement and it reminded me of that Russell Peters. Take it and go.
Sorry, habit. Habit to
Anyway,
today I'm getting my, I got it from just Mr. Soike, Justice Soike, and I've come down. He was also commenting on that. He was on my smile. Well,
I don't know. Have you seen him? He's a comedian, Canadian comedian. Of
his
Indian
videos are there in my lord.
Yes,
My lord, then what happens? But my lord will not say whether that decision, that reasons given are adequate or not.
No, I'm not on that. That's a different issue. I'm not on that. I'm not on whether we can substitute our views to that of the chief or whether he has the power to condone the lack of LLB degree. That is a different issue. I am more on a
My lord, that aspect I really appreciate, my lord. That is there. What my lord has said. Tomorrow, Honorable Chief Justice is upon. He finds, say, well, I'm in the registry, me to be good. He takes me. But say after a few months, finds me not to be up to the expected level. Then, my lord, whether he will have to bear me all along till his tenure. Because he cannot, because I've committed no misconduct, he cannot go against me. What will be? Well, that's exactly what happened. This man was brought in. He was there for nearly, my lord, I think 2 years.
No, that is one aspect.
Lordship.
Now you
Then that regularization took place.
No, and that is one aspect. Now look at it another way.
Lordship.
There are recruitment rules,
Lordship.
service rules made for recruitment of people.
Lordship.
And there is a relaxation clause.
Lordship.
So some discretionary power is given to the appointing authority to have them. Now, can you use that discretionary power when there are people who are eligible for that?
That's it, my lord. That's the difference here. The word used here is found suitable by the chief justice. As my lord said, that the man is somebody who he feels will have his confidence. This post is unique. My lord will not even, my lord, measure or compare this post with the other normal service posts. Because this is a post wherein the rules itself say, the words are, my lord, Because that's what I was trying to, my lord, get across. Here it is considered suitable by the chief justice. Sole. It is satisfied. Is because there may be 100 people. He finds one of them suitable.
And now, supposing a new chief justice comes up. He doesn't find him suitable, he finds another one suitable, but the post of it, then what to do? He has to bear with that unsuitable person according to him.
No.
Then what to do?
No. If that be so, because being a chief justice, secretary to the chief justice, he having been placed in class 2A, he can be, my lord, adjusted. Same thing, against an equivalent post in the cadre, at service.
So from two
A-
C, from two C, what is the promotional post of two C?
2C, my lord, those posts, only the post of assistant administrative officer, judicial, stamp reporter, assistant librarian and senior system officer, I doubt. These posts have promotion level. Other posts have got no promotion.
AOJ does not have promotion.
AOJ has a promotion. Stamp reporter has a promotion. The assistant librarian has a page 79 of that one.
It appeal five. Just a minute. No. Page 79.
70. My lord will have that. Page 70. It's unique because,
No.
my lord, a person enters as a judicial
No,
assistant.
this registrar, joint registrar.
Ah.
As a AOJ,
AOJ,
court officer and protocol officer, they are of the same grade, correct?
right.
And now, so AOJ can go to assistant registrar,
Lordship,
deputy registrar, joint registrar.
lordship.
Now, a secretary to the honorable,
Chief Justice equivalent to assistant register, he
But-
can be considered for,
Ah.
or after some time, he can be, next promotional avenue would be deputy register.
show me the route.
And that consideration is already made and they put it to challenge. This honorable court, my lord, kept it in abeyance, so we have not opened it. It's kept in seal. The consideration of, Nirud Chowk.
So he takes a hop, step and jump.
It's because of the work load he has discharged. No, it's nothing, my lord, any favor made to. He had to slog for. No risk. He had taken the risk. My lord would have page 649.
How is the promotions made to this class 2B? They're different.
Class,
Class 2B, they've got a higher pay scale than
my
class
lord, just
2C.
class 2B.
They're
No,
private
this
sector-
is a private, that's a different category. altogether.
Then
It's
from-
between
So from 2C, they go to
2C, they'll come to, my lord, 2A, that is assistant rate. Normally, normal chat. I got what my lord's requirement is. I'll make a table for that and I'll fetch it. No, now I know where I have to go, where I have to, my lord, produce. The records are there, my lord. We have made a, my lord, index. Just, there was some correction to it. I'll make it and I'll fetch it. Before so that my lord can also, before the next day, go through it. And then my lord would understand. My lord, there may be lackings, but what I'm trying to express upon my lord is, there may be lackings in the procedure we have adopted. But the procedure that we have adopted at the time of its adoption and its implementation was proper. Today, my lord finds that there is a need to improve on. My lord can always do it in the administration.
No, it appears from your appeal and the rule that the basis for putting this secretary to CJ.
No, secretary to CJ, why it has come? Because there was a registry note. When it was placed, that his appointment in the protocol officer was with this condition. So if he is appointed, this should be re-entered. That is how my lord it came. I can show from the record. Unfortunately, that's exactly what has happened. There was nothing prescription, my lord, that this should be the way it should be done. The registry put up a note when he was selected.
No, but your page twenty-two.
That is, my lord, in 2003, that was the.
But then why are you putting two
I put
thousand
it-
three note here?
I put,
Why did you put it?
my
here?
lord, it's my mistake. It's a mistake.
Okay.
But I wanted to bring to your lordship notice exactly what, my lord, I should not be, because both
No,
these
no,
sides,
no, yeah, yeah.
both
no.
these sides
No,
are
no.
our employees.
You see, because there has been no improvement on that page 22, 23. Now, when 22, 23 is there, that is the basis for having placed this secretary to CJ
I'll
in 2A.
contrary to that, I'll show
Ah.
that is not the basis. It is because of the registry note.
Now,
It has changed in the.
where is that in your appeal?
I'm resting.
Huh?
with it. That's why I put it. No, I'm saying I
No, no, you-
represent
you
the
guys-
registry, that's why.
You see, this is a view, can always be changed.
Lordship,
Laws can be changed, everything, and laws have to change. Otherwise, laws if are static, it will never grow. So there could be some reason we don't know. And later on, there'll be questions for you also, I think. Ah. Anyway, we'll have to see.
my lord would, my lord, just take a note, ground H,
Round eight.
H. Sorry.
Page?
sorry. Page, my lord will have page 29. Ground G, H. I. I have stated that here. But I'm not withheld anything. What I am submitting before my lord is there in I.
I'm not saying you've withheld anything.
No, my lord. But
I'm just
2003,
saying,
that was only to explain the position.
I'm just saying that.
2006,
it
changed. The position changed. That, no,
Where
no,
where
no.
is
all-
that? Where is
but-
that?
huh?
Where is that?
No, no, my lord, 2003, there was no rule. This
No, I agree.
3A was not
No,
there.
no, I agree. There was no rule. What I'm trying to say is that
Lordship,
the reason for there being a post of secretary
lordship.
and the method it was to be filled and made vacant has been provided there.
Lordship,
Now you have made a rule which is not in consonant with the reasons given for having the post of secretary. That's what I'm trying to say.
2003, that was the position. 2006, when these rules were made, my lord, with just read, I'll place it. to you. The post of secretary so-and-so is an in-cadre post included in class 2 of schedule 1 of the rules. Being a cadre post, the rules must contemplate and provide for direct distinct channel of promotion, including further promotion to the next time. The in-cadre post, in my considered view, ought not to be filled up at all times on ad hoc or temporary basis. Such, my lord, it says the in-cadre post, in my considered view, ought not to be filled up at all times on ad hoc or temporary basis. Such course of action may act as a deterrent for meritorious employees from joining in the post of secretary to the Honorable Chief Justice and may further have effect of adversely affecting the promotional avenues in the feeder parent post. So and so consequently, I in exercise of powers conferred by me 229, make the following amendment to Rule 7 of the Guwahati High Court rules, so and so. Rule 7(3)(a) was incorporated. This rule came 2000. That's how it is evolving. It's not that, my lord, for the first time, a person like Niroj Sharma had come, this whole thing was changed. No, man. And even, my lord, I have my doubts whether even he knew that his case was under consideration. Because it was not application made. It was sent by the registry. All the
I'm not on that. Whether he knew or not, does not know that
Not
is
sure.
different. I know we'll have to see that, but what is that? Just show me that particular thing here. Very interesting.
I have started asking everything I have to. That is the file pertaining to the secretary.
My predecessors also recorded the view that the appointment in the post of secretary to chief justice should be made on ad hoc or temporary basis.
But this other particular.
So as to enable the chief justice to require the instance. This petition goes over the rest of the- and the period between- The post of secretary is on the character of the secretary. Consultant for the existing channel of promotion, including further promotion in this time. Thus, in channel post is made ought not to be appeared at all in a matter. Such course of action may act as a deterrent for whether some that amendment to the service will be made by providing channel of promotion to the post of the and service. Promotion will be made on a regular basis. Considered suitable by the changes. Yes,
Trying to reach that pinnacle. Maybe we are not there, but there is a evolution. From 2003, 2006, this rule comes in, gives it to the chief justice. Then the selection happens. There are many people who have in the meantime come, they shifted out, and now that is also provided for. They are given a channel of promotion so that they don't stagnate there. They become deputy registrar.
what was the procedure followed for promotion of this person?
This, but not with regard to the post of secretary, all the particulars, there, all the particulars of all incumbents, this sum it. With, in case of Niroj Sharma and one another who were there on a, with that statements of everything was placed before the then chief justice.
How many persons is the
All, there was none left, all. in this 2A, 2B, 2C, whatever is there in 7 3A, all with. Then the selection. And that's the norm. Because it's the Chief Justice who goes through, derives the satisfaction. And then because he had to condone, oh my lord, relax certain qualification, that's why he had to give a reason. Otherwise, if it is an appointment directly under 3(7), a person is chosen, no reason is called. Because he might be a Chief Justice, but he's bound by it. That fine with law qualification not being there. He had to, my lord, give reason, which he was given. He has given. My lord will examine. Whether it, my lord finds it to be purpose, have nothing to do. But my thing is, the honorable single judge has found it to be inert, which I say, humble subject matter is. My lord, two things I'll do, madam. I have the records with my lord before the next date of hearing with index. I'll hand it over. May go through it once before my lord next date. So that my lord gets an idea. I may be wrong, but my looking at it may be in a different, maybe bias, because I'm trying to support the action of the bill. My lord will have an independent, my lord would have an independent look. Then my lord would understand the process in which the registry was working in these times. And my lord, I still stick to my argument that when an incumbent is placed, given a charge, not giving a charge over head. If it's giving a charge of the higher court, it's 49C. It's only the charge allowance he might be affected, not attacking that.
Okay, one question I was asking. This appointment to the post of PO on temporary basis, it was not regularized.
Now what happened? I'll place that. He went as officiating basis as secretary. So that post fell vacant. The next person who came in was appointed on officiating basis because Nirut Sharma was Chief Justice Secretary on official. It's there.
No, I'm talking about Niraj Sharma's appointment as
Because
PO.
why it was?
Temporary.
Because the administrative committee did not evolve thereafter. Thereafter, the administrative committee or the rule making committee did not evolve the matter. Thereafter, it remains stagnant. It prescribed that maybe with the intention that we will look into it. At that point of time, something was to be done, it was done. We will look into it. That looking into did not happen. And by the time,
Did not look into the regularization aspect,
No.
you mean?
as to how to further evolve that concept, that post, because in the rules, there was nothing much. How to evolve that further,
Which post?
that PO. PO filling up is not there in the rules. How you fill it up? So it's by the administrative committees, rulemaking committees, my lord, resolution. It is being done. So first, it was promotion, then they extended to nomination of my lord, options, selection. There is a due process given for the selection, then marks, on the basis of marks, appointment. Now from there, it did not go further. When it came to my notice, my lord, I tried to take it up with the registry, then they said that no, now the matter becoming subjective. We will not touch, we will not trouble, we will not touch. I said fine, let the matters be over, then you can. So till he is there, my lord would see one thing, my lord, the beauty of this. He is a SJ. He comes here, he becomes a cadet. So my lord will have to give some value or some, my lord, reasoning to that. So when he is there as a protocol officer. And if he is there as a protocol officer, because that is the manner in which it has been directed to by the provisions. It does not say that if you go there, you will not get your, only you will get your charge allowance. Nobody will go, my lord. If my lord can have it on Wednesday, Tuesday, I'll give this whole thing. Only I'll have, my lord, thereafter 20 minutes. That's what,
What do you think? What do you think? I'll have time to go through this.
that's true.
I am going to Mizoram tomorrow. So I'll be back on Monday.
Monday is a holiday.
On Monday, that time coming back on Monday.
Lodge, Monday.
I cannot carry.
I understand. My lord will not. My lord will have it on Thursday then. Thursday. I'll give it to you, my lord, on Tuesday. So that my lords would have some time.
Or we can have it the week after that. On Monday or something.
Monday, but then my lord will have more time. Fine.
So that at least in the weekend, we can have
Lodge,
some time to
lodge,
go through
lodge,
it.
lodge.
Otherwise it
Fine,
will
lord.
take time.
Fine.
No time within the weekday.
No need. I'll certainly say Monday. My lord will have it on Monday if possible. my lord.
Yes, can have.
Fine.
Mr. Manta, 9.
Right.
We'll have it at 2 o'clock.
2 o'clock. Fine, lord.
Because this special DB is the main.
My lord will have it. We'll finish now. Subject to what my lord would have. And I'll give this record by Tuesday. Tuesday.
You don't have to give me on Tuesday, you can give me on Thursday.
Thursday, fine. I get more time to now. My lord.
Yes.
I'll
No, because I won't have, you give me on, I won't have weekdays to where no
My lord
time
cannot.
at all. Therefore, no time.
It's true. man. There is no need. I'll give it on Thursday. I'll
But
give it with the
that I-
court master. The record that I told the court master.
Right. As agreed by the council for the party, this is the matter on 9. 9, okay. So it will be at 2 p.m. Huh? So that's
So is it interesting? This is unique. That's what I would like to impress on them.
We'll have to set the things aside.
or
Yeah,
make it more
unfortunately, my lord,
confused.
There is also a limitation here, because the rule is not a question, it's not. So, lordship will have to remain within the 4 corners of the clinic, that the case that.
Yes, now one thing is that with regard to the resolution passed by the committee, would they have the same binding force as executive instructions?
My lord, it could be an executive instruction as per my submission. That will, because there is a gap in the rule. So that would suffice.
So those resolutions would be akin to executive instructions.
Because it's basically an exercise of power delegated by the to the committee.
And whenever new resolutions are made, different resolutions are made with regard to the same code. So we will have to follow the latest resolution.
Because that's the decision of the appointing authority.
And not in, since the things are evolving, my lord.
Yes.
Every day we are improving.
Yes,
So also the system here,
that is,
Now my lord has got a hang of it. So my lord, there will be further improvement. Other side. I have been trying. I've not been able to.
it will, so.
either we improve it or we create more confusion.
I know,
My lord, what I found is,
it will help
there
improve.
is problems are faced, that is being fixed. That's how my lord the being moved forward.
It will help.
Anyway, you should go and see Russell Peters. You see his hand movement.
My mother used to say,
Yes.
my hand tight.
Then you won't be able to speak. Like the Frenchman. Frenchman also a lot of movement. Like Indians, we have got this.
That's why I talk to her.
It happened, my lord, I recollect one incident. That time. It's just a long time back, my lord.
Yes.
The Division Bank, this was being happened by
other side was represented by lit at our senior advocate that time, Talukdar,
Ah.
Chicken Talukdar.